My name is Matt White. I'm a partner with Monty White, LLP, in our international headquarters in San Rafael, California. We have a broad practice area, estate planning, IP, construction defect. My practice has been personal injury for roughly 40 years. The name of the case is Carissa Copeland against Desoto cab and the taxi cab driver. And the overview, at its simplest, it's a low-speed rear-end collision on Highway 101 with no significant damage to the back of my client's car and no injuries at the scene. What made it a little more complicated is that this was one of 3 accidents in which Ms. Copeland was involved in a 2-year period. And as a consequence of all 3 of them, or some combination of all 3 of them, she was determined to be totally disabled from employment by her doctors and by the Social Security Administration. So the key question at the trial would be, what role did this relatively minor crash play in bringing about her total disability? And of course, the defense argued she wasn't totally disabled, so that was an issue as well. What makes it unusual is that this is a low-speed rear-end crash with no injuries at the scene. Those cases typically go for $5,000 or $10,000 or $20,000, and this one went for about $11 million. So that's what I think is unusual about the case. It was a pivotal moment during the deposition of the defense doctor. The defense doctor was testifying at deposition that she wasn't really disabled, that she could do anything she wanted. And I said, really, anything? She could be a construction worker? And he said, well, I don't think women should be construction workers. And I said thank you and moved on. But that became a mini theme in the case because I think the jurors, especially the female jurors, understood that he was just the latest in a long line of male doctors who dismiss or disrespect women's health issues. This was just the equivalent of 100 years ago saying, oh, it's just hysteria. Another pivotal moment was deciding the nature of the jury verdict, because there were 3 different accidents. 2 of them had already been resolved. So this case is going to trial on whether or not this relatively minor rear-end case was a substantial factor in bringing about her disability if she is disabled. But a pivotal moment was changing my attitude on that. And instead, what we asked the jury to do was to evaluate the percentage of harm this accident caused compared to the others. If we could demonstrate that this accident was even 1% cause of the accident, then the defendant would be on the hook for 100% of the economic damages, and that was the big part of our case. The net result was a finding that the plaintiff was totally disabled, incurred a lost income past and future of around $10 million, several $100,000 of economic medical expenses past and future, and that she sustained, I think it was $300,000 in pain and suffering damages. And then the key result was that the jury found that this particular rear-end case was a 3% contributor. It was a 3% cause of her disability. So the net benefit to client is not yet economic. The case is on appeal. The net benefit to the client right now is that she was right. And her last lawyer, the lawyer before me, was pushing her to settle for $100,000. And when the bidding got to $200,000, he was desperate for her to take the case. And when she didn't take it, he withdrew. And she was prepared to take the case to trial, even if it meant she lost, to prove her point, and she did. Well, I'm proud of a big verdict, but I think I'm more proud of the fact that I took it to trial. And I'm proud of every lawyer who takes a case to trial on our side of the V. Well, my client was fantastic, of course. My legal assistant, Darcy Lichter, was fantastic and kept my office running for a month while this case tried. I am really grateful to my jury consultants, Dr. Will Roundtree and Dr. Alexis Forbes of Benora Roundtree. And they not only helped me craft useful opening and closing statements, but they saved me from some very serious mistakes on voir dire. Really appreciate the SFTLA for all of its support to all the lawyers in our group. The listserv is a fabulous resource, and gained a lot of useful information for this case and others through the SFTLA, and a number of other lawyers who helped. I'd like to think that it was all me and that it was my genius and skill, but it took a village, as it does for all of us.